Welcome to JustWannaQuilt, a research podcast coming out of Tulane University Law School, where we explore all kinds of things, stories about quilting, tools, field trips, maybe some famous quilters stop by, and, of course, a little bit of copyright thrown in just for fun. I'm Elizabeth Townsend Guard. I'm a law professor at Tulane University, and I just want to quilt. So today our guest is Chris Reed. He is a copyright attorney in Los Angeles for the entertainment industry. He is super smart, so smart. He also used to work at the Copyright Office. That's when I first met him. He teaches media law, writes books, and he's a professional photographer. He is just awesome. So we kind of geek out. I hope you enjoy it. If you have questions, go to our Facebook page and ask them there.
I'm doing pretty well. It's been a while. It's good to talk to you.
It is great to talk to you. It feels like forever. It's so amazing to chat with you. Like, so many things have happened in your life since we last chatted. It's so amazing.
I know. It has been a while. I think the last time we spoke was when I was on my way to or had just arrived in LA.
Yeah, exactly. That was a while back.
Hard to imagine it's been 4 years.
No, it really has. It's what happened to the time. Well, I'm super psyched to chat with you. Are you cool with us recording this? And you can review it before we post it.
Okay, great.
Cool. Well, what I thought we'd do today, if you're cool with this, is I have a list, but I'm sure you have some thoughts. What this is a quilting podcast, and we talk a little bit about copyright, and then we have people on like you that talk a lot about copyright and a little bit about quilting. So, but I'd love to chat with you about your book and about photography, and about content owners and their perspective on what people are doing when they're doing crafts, because there's a lot of confusion out there. Does that sound like a good agenda?
Yeah, that sounds great.
Okay, cool. And we go... we try to go half hour, but usually we end up talking a bit longer. So we don't go longer than an hour, but between a half an hour and an hour, depending on the conversation. Does that work for you?
Yeah, that's fine.
Okay, fine. And you're okay with us recording? You already said yes?
Yes, that's fine.
Awesome. Okay, cool. So we're going to start with, we're preserving these and donating them. So I know who you are, but can you tell me your name and where you're calling from?
Yes, I am Chris Reed. I reside in Los Angeles, California, where I am a copyright
Chris,
attorney.
Hold on. I forgot to do it. Let's do it one more time. I have two recordings, but our backup recording I forgot to put on. So let's do it one more time. Chris, tell me who you are, Chris.
Sure.
Where you're calling from.
I am Chris Reed. I am in Los Angeles, California, where I work as a copyright lawyer in the media and entertainment industry. So
very cool. Do you have any memory of anyone sewing or quilting in your life? That's the first question we always ask.
My mother did, but I was never particularly involved. But she used to do a fair amount of sewing. I don't think she did any quilting per se.
And you are, I'm really psyched you're here. Like, I have to tell you, like, I know we haven't seen each other for a while, but you're just so cool. And I have so much fun when we hang out at conferences. And, you are like the perfect person to talk to us. Right now I'm trying to write a small book for quilters, and I have a bunch of questions that I'm curious about what your answers are. But you're a great intersection because you work in the content industry. You're also a photographer yourself, and you've also worked at the U.S. Copyright Office. So you were in the belly of the beast. And then you also have written a book for photographers. And you also write for, is it Art Journal? What do you write for?
That's right. So I write for an online publication called Art Law Journal and its companion publication, Entrepreneur. Both of those are run by a company called Orange Genius, which is setting up a platform actually for visual artists to help them not only understand the business aspects of their craft, but to kind of market themselves and
That's really great.
Eventually provide some back office support for those types of
That's really cool. If someone's tell me again the name of that. That's really interesting.
Yeah, it's Orange Genius.
Orange Genius.
OrangeGenius.
Orange Genius. Orange Genius. Creativity discovered. Well, that's really interesting. I love it. And have you been, because you also have a book on entrepreneurship, have you been involved with their thinking through on this stuff of how to help?
Yes. Yep. So I've worked with them actually for about 4 years now, 3.5, 4 years as an advisor, kind of helping them think through not only the product offering in terms of how they can help photographers and other visual artists, and eventually artists generally. I mean, not just visual artists, although that's where it started. But how we can help them. My angle was help them understand copyright issues, which is the same thing that you're interested in talking about.
Yeah.
But also just general kind of business. And so, yeah, I've been sort of with them from the beginning in various capacities, just helping them think through those issues and what the product might look like and things like that.
And how does art get defined? Like, I see it says fine artists. Are you a creator? It says photographer, designer, galleries, institutions. Do you have, like, is it paintings? Is it anything? Like, how do you define what an artist is, a visual artist on your platform?
Yeah, that's one of the things we've talked a lot about. And where that tends to come up for me is, you mentioned I'm a photographer, and that's right. I obviously don't do it full time. And my perspective on the way I quote unquote sell or license my work is very different than somebody who might be, a quote unquote fine artist. Right. Who is selling a particular copy, and then that's that. I sell most of my stuff through stock libraries, so it's my business model is different. And so we've sort of tried to figure that out within the context of Orange Genius, like who we're going after. And the answer really is platform works for anybody. Yeah, so it's all of that. Open. It starts as like I said, kind of starting with visual art, but I think the goal eventually is if it works, is to open it up to other types of creators as well. So musicians and writers, and anyone else who creates work and wants to do something with it.
That's so interesting. That's really fascinating. And what does join? So you can join for free. What does it get you if you join? Like what's happening on that platform at this stage?
So right at the moment, it is basically a platform to help creators, interact with other creators, find collaborators, and then connect people who are interested in either buying the art, and I use buying in kind of the broad sense. So it might be, a licensing transaction, which is not facilitated directly on the platform, but it puts the potential users or buyers of art with the creators. So, eventually they're still in the fairly early days, but, eventually there's going to be all sorts of opportunities to make art available through, partnerships with, say, advertising agencies, for instance, so that creators' works might end up being licensed by, an agency for use in a particular ad campaign or something like that. So that's just one example, but that's really that's the idea.
I so have to connect you. There's this company called Culture Tech. Do you know them?
No, I don't think so.
So Culture Tech's out of New York. It's a startup, and what they're trying to do is create a platform for museums and for artists to clear copyright. They're calling it like a smart contract kind of thing. And they've asked us to do we did some work for them, just like general project for them at Tulane. But they're really interesting. But it seems like you guys should connect. I should put you, because you're doing different things but similar things. There might be some crossover there that might be interesting.
That sounds really interesting. And Orange Genius is actually based in New York. The founder came out of the finance industry actually in New York.
Well, they might know each other.
There,
that's
so
cool.
They may well.
I'll connect you just so you can say hi or see what kind of. They're just building their platform now, so we're helping them a little bit on just the copyright side, the Durationator stuff. My other hat, which is not what I do here.
You're like me. You have a lot of hats.
Totally off topic. I mean, we're on topic, but we got a whole list of things. Okay, so what's interesting is you're on all sides. So I believe that copyright, we are all creators and users of material. Would you agree with that statement?
Yeah.
There's
Absolutely.
no way to be one or the other. It's not like, the owners are over there and the users are on the other side.
Right. Well, and that's especially true today, right? Because we've got, computer technology that allows anyone to create anything and then have it distributed worldwide. We don't need a publisher anymore. We don't need an antenna. Well, this podcast is a great example of that, right? We're not radio broadcasters in the traditional sense, but you're able to push content out. So yeah, completely agree.
And then, so why is that an important thing to understand? Because I think, what people don't get is copyright was made before we all could do this. So it was a document or a law that's really about big content owners to big content owners. It wasn't really made for you and me to be able to post stuff online.
That's true. I think, though, that it maintains its legitimacy, and we still have a need for copyright doctrine, basic copyright doctrine, because I think that and I'm sort of wandering into moral rights, I suppose, but there's a control element there that I think is important even for small creative professionals.
I agree.
And so if if you're a quilter and you've come up with something unique and original, you may not want to commercialize that in the same way that a Hollywood studio commercializes a feature film. But there is still some interest, I think, in controlling that. And one thing I like to point out when we get into sort of the quote unquote debate over, how strong copyright should be and whether it's gone too far and whether it's just welfare for corporations and all that, is there's nothing about copyright law that stops you or me as an independent creator from making our work available for free to everyone online the world over, right? Yeah. But it allows us to have some control over it and allows us to monetize it if that's what we choose to do. And so that's why I think it's still important. And I actually think, obviously needs to be updated, I think. It's 76 is a long time ago, the last Copyright Act, right? But at the same time, I think the core foundations of copyright are still stable and just as much important today as they were way back in the original Copyright Act. Yeah, it's kind of and for those that are really interested in this conversation, you have on your website a debate or a conversation about how copyright would be updated, or a conversation, right? Right. So you can go there. Okay, so let's break this down a little bit. So let's go from the content holders. Now you've been in LA. So when I last saw you, just headed to LA, and now you've been there 4 years. So the content owners, so from a quilter's perspective, the way we interact with Harry Potter or Disney or any of these things come in a couple of ways. First, we buy fabric, or second, we make something that is using the characters. That's the first thing. And then the second one is whether we use it for personal use or we sell it to a friend or put it on Etsy. That's sort of the questions. So I get this all the time of what am I allowed to do, what I'm not allowed to do. And I'm curious from your side if we could go through kind of not for the company that you work with, but just in general, how we understand using content. There's one person I interviewed that is super protective of copyright, but at the same time, she's using Doctor Who in her work. Mm-hmm. So it's kind of confusing, I think, to people to understand that. So can we kind of go through your thoughts about that, about personal use versus low commercial use? I think, and thank you for saying something I should have said earlier, which is that these are my thoughts and not necessarily those of my employer. So just to be clear, and I can't represent that in other stakeholders in this community are going to think the same way. But generally speaking, my view is, and I think you've said this on the podcast before, I forget who the guest was, but you guys kind of worked through some hypos of those situations, certain situations that come up. And one of the points you guys raised, which I think is exactly right, is, how commercial is it? Right. And so when you start to get into areas where a content owner or a brand owner might be occupying, and sort of a kind of reasonable degree of, a little bit out from that, that I think that's when you start to run into trouble. But as a general rule, content owners are not particularly concerned about one-off or even small-scale commercial uses. Yeah. There's also some concern, there's kind of, to back up a little bit, there's two issues. One is the copyright issue, right? So if you're using copyrighted work in some way and creating a new version of it or using it in a pattern or something, you may have a derivative works issue, right? It could technically be an infringement. But there's also, particularly in the entertainment space, this concern over the brand and the trademark. Right. And that's increasingly true in my industry, where we rely a lot on franchises. Yeah. And so in that case, that's more of a trademark issue, where the concern would be that the studio or the TV network or whoever is most strongly associated with a particular program or film could be seen as endorsing that particular product that you have made. Right. And I think for that, context is everything, right? If I see somebody having made something using big brand, and it's, they're using fabric that's been licensed by a big brand, and you've made it into some quilt and you're selling it at a local craft fair, that's very different than I think if you're selling it on a website where that brand name might be incorporated into the domain name, which of course raises other issues, but or it uses the logo on the site or something. It's about sort of the context and the way, and to what extent people. Yeah, is it about the fact? Okay, so let's go through that. So again, we'll use my example that I keep using, which is sort of how this project began, which is I bought licensed Star Wars fabric. Mm-hmm. So Star Wars, the company that owns Star Wars, switched over, but the people who licensed that fabric, they already got their money when I bought the fabric. That's where their
point of, that was where their economic interest was. Then I made it into a quilt and I put it up at the PILF auction for the law students. Do you think there's any problem? There's not really a problem doing that, right? Like donating it to the law school. And I made it, I didn't do anything really, I didn't see any problem with that. Do you have a problem with that?
No, not at all.
Now, let's say I bought like 7 kits and then I started making them for lots of people. You don't have a problem with that either, because I still like paid the money and they got their licensing fee. I mean, right?
I almost see that as more of a, they're paying you for the labor of having put it all together.
Right. It's my sewist. That's my labor. That's what people are paying for. And if I put them up on Etsy, you still don't have a problem with that, or you do? Like, let's say I'm like, okay, I'm just going to make Star Wars quilts forever, and I'm using the licensed fabric, and you're getting your money. You're okay with that?
Yeah, so that Etsy is an interesting example, because I think that's where you start to get closer to having a problem.
Yeah.
And I think that is something that, frankly, the industry needs to think through, because right now, and I'm sure you're well aware of this from the questions you get, some rights owners have a very knee-jerk reaction to seeing things online, period, right? Etsy or otherwise.
Right.
And I think that, because I think your legal analysis, what you just went through, is exactly right. But I think that is where you start to get into a concern over not the copyright interest, but the brand association.
Yeah. Because
you're now searching, like, let's say you, not that you would ever do this, but let's say you used your Star Wars fabric and you did a really terrible job of putting it together.
Thank you, Chris.
And I'm sure you would never do that. But then you have sort of that quality issue, right, that we see in trademark.
Right. So if you're out there putting out crappy Star Wars quilts, that the problem would be that the brand might be harmed by your quilts, is what you're saying.
Exactly. Now, I mean, I guess a better example would have been if I had tried to do it, having zero quilting
No, you're
experience.
Right, Chris. I'm pretty good at copyright. My quilting is, medium. So, well, that's interesting. Okay, so Etsy. Now, what's interesting, I think, about Etsy, and I hadn't really started to think about this until recently, is the problem with Etsy was it's so public. It's you just put in Star Wars and a whole bunch of stuff comes up. But what I'm finding is that people are leaving Etsy, that they don't like Etsy anymore, and so they're creating their own shops on their websites instead of Etsy. I think that makes it better because it's not so public. Like, you have to know that particular designer has that thing, and you go there, and like there's many layers to get to. I just think there's a less brand dilution, I guess, if it's not on Etsy.
That would be I kind of think so. And then just on a more practical level, and I'm not really supposed to say these sorts of things out loud, but it's the enforcement risk goes down, right? Because in many ways, sites like Etsy and any of the platforms where you have a lot of people doing the same thing at once, you kind of have this. It's easy, we know where to look for those sorts of things. So, whereas if you have,
Yeah, that's interesting. Okay, so that's really interesting. Now, the licensed fabric is super interesting too. So we've been doing this. We're doing ridiculous projects, Chris. So the other project we've been doing is there's a woman who is a part of our quilting army who lives around the block who has lots of fabric. Quilters often do, and we've been taking law students to her house to document all the licenses on the fabric that she's bought. And so what I find really interesting is what they're putting, what fabric companies are putting on the licenses, which are they run the gamut. But when I buy fabric, so content owner, let's stick with Star Wars. Star Wars licenses with a fabric company to make fabric that's got Princess Leia on it. Mm-hmm. Then that gets sold to the quilt shops or to Joann's or to a big box store, and then I purchase it. Oftentimes on these it says like for personal use only. Do you feel like that is like, how much can the fabric company limit your use by putting that license on the fabric? Does that make sense?
It does. That is a very tricky question, as I'm sure you're aware, with respect to the consumer expectation of whether what they're getting is a license or a purchase. And, that's something that's certainly affected the entertainment industries because more and more content is being distributed electronically. And so, in copyright, we've always sort of understood this concept of for sale doctrine where the copyright interest is separate from the physical good. it strikes me that if you're going into a fabric store and you're buying fabric with no matter what it is that's on it, there's a consumer understanding and expectation that they're buying an item
to make, right?
And to make, yeah.
Right.
I mean, there's sort of an implied license to make things out of that fabric, right? I mean, there's a store that sells a bunch of raw materials.
Right.
Strikes me as unlikely people are just piling up a bunch of raw material in their closet at home. They're doing something with it, and
right.
the
or at least
seller sold it.
Right. We're supposed to be doing it, right? We all have fabric we're not using, but we're
totally
the goal is, so there's an implied license to make a derivative work with that copyrighted fabric, because that's why you're selling it in the first place.
Well, so query though whether you're, and this is getting kind of deep, but query whether you're even making a derivative work at that point, because you're taking pieces of fabric that have something printed on it, and you're making something out of the physical object.
That's right.
Right.
That's exactly it. So that's the ART cases, right? The conflicting cases. So what we're talking about is, so you have an original work, that's the fabric, which is a derivative work of the original whatever movie that was made. So you have fabric and you sell it. And what Chris is saying is that you take that fabric and you make something of it. You're not changing the fabric, right? So there's no it's not a derivative work. It's just taking the original work and putting it into a form. And
I don't think you've implicated the copyright at all at that point.
It's not affecting the copyright at all. And when you buy a book, there's a thing called for sale doctrine, which says, well, you can resell that book, or you could tear it up, or you could do whatever. But we have these weird cases in art that were about putting, taking a piece of art, was it a book or like a postcard, and putting it on a piece of tile and putting shellac over it. And the courts split. So one court said that it was fine, and another court said that they were creating a derivative work. How do you feel about that? I don't think it's creating a derivative work, is what I'm getting from you, because it's not affecting the. Now, if you took that same fabric and you dyed it, maybe you scanned it and you did something, and if you have to you have to do something to. I don't know exactly what you do with it, but you have to be doing something to it that alters the copyright. And this isn't altering the copyright; it's just cutting it up.
Right. I think that's right. I mean, and again, there may be sort of trademark things lurking there, depending on what you're doing with it downstream. But I don't think that just taking something and kind of recasting the physical object upon which that is really matters, right? Because the copyright, I mean, you have to it's this weird intellectual thing we do in copyright where we separate the work from the physical manifestation of it. So you're not cutting sorry, go ahead.
I'm sorry. So you think that first sale doctrine then applies to me purchasing the fabric, and then I can make what I want with it. Then these licenses really only go to manipulating the copyright, not the physical. I don't know. What are the licenses doing on these fabrics, I guess is my question.
My sense is, and I say this having no actual insight into that industry at all, but my sense is they're putting it on there because a lawyer somewhere told them that seemed like a good idea. And I don't know that anybody really knows the answer to that question, because I'm not sure the person that put it on there thought about it.
It's so interesting. We're trying to get to that answer. But you can put limits on physical goods. I mean, I could sell you something subject. I mean, just like with land, right? I mean, you can sell you can deed some land with covenants, and then you're bound by those requirements, and you can do that with physical objects as well. So you could argue, if I were the fabric manufacturer, I think my argument would be, we are selling you this physical product with the expectation that you're only going to do a certain thing with it. Now, whether that's You're saying the license isn't a copyright license; it's a license to the physical object.
Yeah. Now, I don't know anything about the law in that. I know the license, is it a sale or is it a license doctrine from copyright fairly well, but I don't know what the general rules are on that from just
I'm still working
basic property law.
Yeah. I agree. So so for those listening, just because we just got really complicated on them. So explain why what the difference between a sale of something and a license of something, and why we're talking about that, what the difference is between those two things.
Yeah, well, so basically, I mean, the difference is sort of is embodied in or illustrated in what we've been talking about, which is if it's a sale, the copyright owner does not have any rights to control what happens with the property downstream, right? Yeah. So, or in those cases, the copyrightable work. So this came up in the copyright space in terms of software. where and the facts are rusty, so correct me since you
That's okay.
teach this all the
Me
time.
too.
But basically, there was software that was sold pursuant to one of those lengthy licenses that you click through and nobody really reads, and the software that said you can't resell it once you're finished with it.
Right.
This is where I start to lose it. One court set up a list of factors to determine whether it's a sale or license, and it basically, the way I tend to summarize it is, it basically comes down to what was the expectation of the consumer when they entered into the transaction. So did they reasonably expect it to be a license or a sale?
Right.
And I think in software, things changed a lot when we started getting downloadable software versus buying it in a store. I mean, back in the day, you had to go to a store, you bought a big box that had a disc in it,
Right.
And that felt a lot more like a sale.
Right.
Even though the software industry would characterize that as a license.
Yeah.
Nowadays, when you download it and you click through a bunch of stuff that nobody reads, that does not offend me as much that they characterize that as a license, because that kind of feels like the sort of thing we would license.
Yeah. Okay, here's the thing. Here's my pet peeve. I don't really understand. When you go to Amazon Prime and they say rent or buy, what really?
Oh, yeah.
What? No, right? Like they're not saying that I can take that and give it to my friend, right? Like they're not using buy in a first sale doctrine way, are they? They're just saying a long-term license versus a short-term license.
That's exactly what it is. And my hunch is that a lot of that derives from marketing as opposed to the legal.
It's so interesting. I always wonder, is anyone ever going to call them on that? Because it's so interesting, right? Because it's like you're not really buying it, right?
Right.
And that gets
to this.
Right.
That gets into this whole policy issue that's been sort of batted around the part of the copyright review process over the past several years is comes up every now and then, this idea of digital first sale. How do we deal with first sale in the digital environment? We've had at least one court say that it doesn't really exist.
Right. Which
I think
means
it's just
if it doesn't exist, means you cannot give it to a friend. You can't if it's a license with restrictions, that means that when you download it, there's a whole bunch of restrictions and you have to abide by them, as opposed to if you bought the pattern or you bought the book, the physical book, there may be less restrictions, and that's the first sale.
That's right.
Yeah.
Now, I will just say a lot of the digital content industries are solving the issue of, where this tends to come up is if somebody passes away, what happens to their digital library? Is it really true that can't go to their next of kin?
Yeah.
And a lot of that's being handled by contract. So rather than looking to for sale, you just look at those terms. And I don't know the details, but I know some of them now have specific provisions in place for that, where basically, as long as that content continues to reside in the ecosystem in which it was bought, you can hand it off to somebody else in the event of somebody's death.
That's
or
really interesting. What does
like
the ecosystem mean? Does that mean
Well, the big concern of copyright owners is that that copyrighted content gets out of whatever protections are on it, right? So the biggest issues with digital content is that when you make a copy of it, it's indistinguishable from the original. And so when we license a film on iTunes or Amazon, Amazon or any of the downloadable services, there is digital rights management. There are technological protection measures on that prevent you from making a copy of it. Yeah. And when I said outside of the ecosystem, all I really meant was that's a term I made up, by the way, and not any kind of term of art. But it is basically what I was saying is it needs to sort of exist within that universe as opposed to you can't just burn a bunch of stuff to disk and then hand it to your friend and say, no, we're good because it's in the license, right? So it has to be within that kind of, you're basically handing over.
Your aunt passes away and she's had a whole bunch of digital patterns on her computer. You can take them off that computer and put it on a different computer because it's still the same kind of it was hers and now we're just moving it onto a laptop because her computer is really old. That would be okay because you're not taking all of her patterns, just putting them up online. That's really the problem, right? You don't want...
Exactly.
Yeah.
Yeah.
All right. So I've got more questions. So the pattern makers, the people that make patterns. So patterns being I'm going to make a quilt that has an elephant on it. And there's a way the pattern will teach me how to make the elephant. There's a couple of questions. First, what's protectable about the pattern? Because do you think that the instructions on how to make the pattern, this is your art stuff. When is the pattern art and when is it more like a recipe? Does that make sense? It's teaching you how to make the elephant. So is the recipe protected? Like the directions protected or not?
I haven't thought about it, but my initial reaction is that is an awful lot like a recipe.
Me too.
Which we have pretty firm doctrine on that says that's not protectable.
That's right. So what's interesting about it, and I think my head is exploding from this stuff, because copyright does that. It gives you headaches, right? No matter how much you know about copyright, you just like, it hurts. Is that what the directions are doing is helping you, if you follow those directions, you will build the art. And I think that's really interesting, because I think about like art, like the art itself is protectable, but the exact directions to build that exact thing is not, which I think is really interesting.
I wonder, so the immediate analogy that comes to mind, and I don't know the answer, but the thought that came to mind was how do they handle installation art, where you're doing something in an environment and there's usually some direction. I just remember seeing something at the National Gallery when I still lived in Washington that explained how a particular piece was put together, and it was basically a set of instructions.
Yeah.
And I wasn't sophisticated enough then to think through these copyright issues.
Yeah, it's so interesting, right? It kind of like, my kid was always like, well, it's the final product versus how you get there, which I think makes a lot of sense. But then you're like, well, if you follow every single thing, it's going to be the artwork. So how is that not protect? You know what I mean? Like, it's a very interesting line of weirdness.
Because I wonder though. So typically, when we talk about recipes not being protectable, you're talking about the recipe or a collection of recipes as recipes.
Yeah.
Whereas, right, and so the final product of that is usually some dish, and that is not copyrightable. Whereas here, what you're describing is instructions that ultimately create something that is protectable.
Right.
And so I wonder if that changes the analysis. But then you also have this odd layer of, I might not follow the directions 100%, either because I don't want to, or because I don't know what I'm doing. Right. I'm terrible.
Exactly.
And so,
exactly. There's always a moment in the directions when I go, I'm like, oh, forget it. I'm doing it my own way.
It's like putting IKEA furniture together and you don't know what that extra piece is for. So you just say, forget it. Is that then original to that person? And have you then altered the copyright ownership?
Have you created a derivative work?
Exactly.
Right.
Yeah.
I don't know. I'm kind of confused. I mean, like, this is like hurting my head kind of thing, because we all know, and Chris and I have been raised, because we are good. We practice. It's like catechism or something. We know copyright law, and we know recipes are not protected. It is so easy. And this is more like a recipe, but then you think, well, is it? So I don't know. So that's the first part. The other question that comes up is, if I take a pattern and I put it out as a PDF, is it protected differently? Is it protected like a license than if I print it out and sell it at a store in a copy? Are there different restrictions on what I can and can't put on that rights management statement?
Well, as a practical matter, if you're distributing it electronically, you have a whole new world of rights management options available to you, whether or not those are rooted in sound copyright doctrine or not. Mm-hmm. You could restrict, for example, with using PDFs, you can restrict the user's ability to print it. You can restrict their ability to forward it to other people. Yeah. And things like that.
Right. The logistics. You can do a ton of stuff with the logistics so that pattern doesn't go out.
Exactly. Yeah. Right. But I don't think, and again, I haven't really thought all this through, but my initial reaction is I don't think the copyright argument changes unless the context in which you're buying it makes it very clear that it's a license.
Yeah. And so, Brandy Carl? Do you know Brandy?
No, I don't.
Oh, you don't? No. Okay, so Brandy is, she worked at Stanford for a while. Now she's at Penn State. And so she said she believes that if it was a downloadable pattern, it was a license like software. But that if it was sold as an analog pattern, it wasn't.
Yeah, that's kind of where I'm coming down. But I think that I would add to that in the context of downloading it, I would expect to see some language on the site or service where I'm downloading it that suggests there are restrictions on it.
Right, so that you need to have that before you get that. You have to be on notice that there are restrictions before you download it, so that you don't get into a situation where you've downloaded something thinking you could use it commercially and then you couldn't.
Yeah, which is basically what those software cases we talked about a few minutes ago say.
Yeah. Okay, So what about the pattern? So I get a lot of. We're also collecting patterns and looking at the copyright notice and the right statements that they put down, and a lot of they put down things like you can use it 18 times but then after that you have to buy another one. Like, can you, on a pattern, on a book, like your book, you wrote a book, could you put, I don't think they can put that restriction. Do you think they can? Like, I think I think for sale comes back in, don't you?
Yeah, it's interesting because the analogy I'm drawing now is to stock photography, actually, where often, if you license one of my images from one of the services I sell through, you can use it in a print run of up to X thousand. I don't know what it is offhand, but it's some number of copies. And then if you exceed that, you have to kind of get the next license tier up. So it's kind of like that. But again, if you're talking about, I think it comes back to whether it's a sale or a license. And if it's just a physical product, I'm not sure that there's much ground in copyright law to enforce that.
Yeah, I don't think so either. Now, I think that, like, maybe if you do a downloadable, I think it's harder to enforce, and it's kind of weird. Like, so then the other thing that I see is for personal use only. So I get a pattern at a shop, and they're saying to me, you can't use this and sell it someplace. So do you think they can put that restriction on a pattern? Could you do that for a book? Could you... It's weird, right?
Well, the example, I mean, it goes back to what I was saying earlier about, whether there's something in property law that allows you to do that or not. I mean, the example coming to mind from outside of this world is textbook review copies. Back when those were sent in hard copy, they always were shrink wrapped. And I'm sure you get plenty of them.
They do them digitally now, though. They don't send. So they used to just send you gobs of these books, right? That, like, you didn't ask for. Like the music industry with all the CDs, like when they used to do that, right?
Yep.
And they just show up. And so law professors, at least the ones I know, we'd resell them, right? We'd, like, go to Amazon and because we didn't ask for them, right? So then they put these stickers on them of, like, you're not allowed to resell them, which was stupid, right? Because that was what was weird there was I think they would have taken the position, and I don't know that they ever said anything publicly, but they would have taken the position that the provision of that textbook was conditioned on certain restrictions. The thing that's weird is you didn't ask for the textbook; it was completely unsolicited, and it was like a gift. And I think for sale applies, right? Like,
I think so.
Yeah. So so these patterns. The question is how far they can go in restricting it. And again, is it the physical? It gets back to that weird thing with the fabric. Like, what is it that you're getting, and what part is protectable and what isn't? And I don't think it's super clear. Right.
Yeah, and you raised, and let me just go back a second. You raised an interesting point about how you had more enforcement options if it was digital, putting aside the legal issues, and that is something that's true generally in the creative fields. Is that because digital technology, it's sort of the quid pro quo. Digital technology is ubiquitous and you can get content anywhere, anytime, on any platform. That has also allowed us to put in these rights management tools that allow you to restrict things and make it a little bit easier to enforce. On the other hand, when something gets out, it spreads like wildfire, right? Yeah. And so that's the thing that our industry suffers with, suffers from a lot, is when a movie gets pirated, it is everywhere immediately. You don't have to go downtown to the seedy street to buy the bootleg DVD anymore. You can just Google it. Yeah. And it's the film is right there.
It's a mess.
But I think the pattern manufacturers are probably trying to prevent that from happening within the quilting community.
The pattern industry is really messed up because a lot of the big fabric companies are giving them out for free, and then, like, the little pattern makers are trying to enforce the people are swiping theirs. And then there's all this public domain. They're using public domain images, and and it might be a recipe, so it might not be protected. It's just like I think it's the biggest mess I've seen so far. So let me ask you, so the pattern makers, let's go back to them. So we don't know what kind of restriction they can put on the pattern at the shop, but you're saying what? That the restrictions that are on that, can they say for personal use, do you think? Can they restrict the use of that pattern?
I mean, I think the answer is rooted in basic property law, and that's the part I don't know.
So more research.
Yeah,
I agree.
Right.
Okay, cool. We're at the same level, because it's funny because I feel like, wow, like, why do I not know the answers? Because they're really hard. Okay, So then someone takes their pattern. What can they do about it? Like, the other part of it is copyright enforcement's nearly impossible. At least in a non-digital environment. In a digital environment, you've got notice and takedown and all kinds of things you can do, right? But even
You
then
do,
it's hard.
although I'll just say, I mean, yeah, the notice and takedown system, doesn't really work from my perspective
You don't
because
think
it's
so?
based on per piece of content. Yeah, this is where my views tend to be very, very content industry oriented. But the frustration is, there are you just use movies as an example. I mean, there are thousands of instances of popular movies and TV shows online. And each time we find one, we have to send a takedown notice for it.
Yeah.
And there is no requirement in the law that anybody do any kind of filtering. And certain platforms do, like YouTube, for example, has basically a filtering technology that they will allow certain rights owners to use.
Yeah.
But that doesn't help small independent creators who then have to troll and send hundreds of notices. And so we hear sometimes independent filmmakers and independent photographers and perhaps also pattern makers that end up having to send, they spend half their day sending notices out.
Yeah.
Something comes down and then the person just re-uploads it.
Yeah.
And you're supposed to have under the DMCA a repeat infringer policy if you're running one of these platforms, but that aspect of the law is still fairly nascent. There's one case on it, but it's very fact specific.
That's really interesting. So it's not working from your perspective. The pattern
No.
makers get very upset about all of this, about people taking their patterns or copying them. There's like underground, like almost Napster pattern things happening.
Mm-hmm.
What kind of lessons should they be taking away from the large content owners about this problem? Like, what should they be doing or thinking? How do they think about this when they see somebody doing things? Yeah,
that's a really interesting question, and it's I'm afraid the answer that comes immediately to mind is not that fulfilling, because I would say we have had trouble keeping up with it, and we have, our industry is probably better resourced than your average small,
right,
pattern
micro
creator.
entrepreneur that's got a couple patterns out there, right?
Yeah, I mean, we have, that's what my department does, is handles that sort of notice and takedown process, among other things. But we have a whole department that does it. Mm-hmm. And so an individual is really kind of swimming upstream. What I tell photographers is, just kind of be... You see a lot of photographers in particular, and perhaps other small creators, kind of go too far the other way and just treat everybody like a thief.
Yeah.
And so you go to their website and there's all these nasty statements and just, flashing red text and don't steal from me. And that's how I put food on the table and all that. Right. And that's all true. And I feel I feel for them. But at the same time, it does not create a very endearing environment where I want to help them. And so that's one of the things I have in my book is, don't be a jerk. Yeah, and it's sort of tongue in cheek, but it's like, if everybody sort of plays nicely in the world, in the ecosystem, you're more likely to have people respect you. And we see examples of this sometimes when creatives will put things out on sort of an honor basis and say, well, pay if you can, or pay what you can. And I'm skeptical of some of those, because often they're put out by people that already have a strong reputation, and so people are more willing to pay for it. Yeah. But it's tough. And what I would suggest is to police the major sites and services where they find their stuff being infringed. Yeah. But it's difficult when you're trying to be a creative professional, and that's how you
because they're
make
your
money.
Fan base, right? That's what the content industry learned, is that, and we had some backlash on our Facebook group when. So we had a situation where the pattern people were like, don't steal our patterns, blah, blah, blah. And then the regular people like me were like, well, one person's like, well, I'm not going to buy any more patterns because it's too stressful to know what I can and can't do. And I'm just going to make my own. So you could kind of see that backlash of they're your fan. That's your fan base. Be nice to your fan base. Don't piss them off, I mean, it's sort
of interesting, though, in a very academic sense. What you just described is almost, it sort of does advance copyright's goals, right? Because they got so frustrated with not being able to use something that they created their own, which enhances creativity, which is kind of a backwards way of looking at it.
But so
at
weird,
the same
right?
time.
Yeah.
Really
the other thing, do you suggest the photographers to put Creative Commons licenses on their photographs? The quilting industry is not using CC licenses at all, and I'm curious what your thoughts are about Creative Commons license. And explain what those are, so in case people don't know.
Sure. So Creative Commons licenses are basically structured licenses that have been boiled down. There's legal licensing language behind them, but they've been boiled down into these fairly easy to understand phrases or terms, for lack of a better word. So you can release something to the world that is still copyrighted, but is subject to a Creative Commons license, but it might allow somebody, for example, to share it with somebody or create a derivative, provided that that person share that derivative on the same terms that they got the original work or something like that, right? So it's a way of kind of loosening copyright restrictions in a structured way so that we don't all have to become copyright lawyers and learn how to write formal licenses. I like that Creative Commons exists in the world. I think it's filling an important need. And I think for people who understand it and want to release their work that way, it's great. What I am concerned about is, particularly in the photography industry, we have seen a number of platforms that allow people to distribute, sharing platforms and things that default to a Creative Commons license when you upload something. Right? And so that is, to me, kind of, I don't know if it's intentional. Evil, right?
It's not cool. It's like stealing your property right by doing that.
Exactly. When
SSRN is where we put our work before we publish it as scholars, right? And then there was a competing one, and their default was a CC license that gave away all the rights. And I wrote to them, I'm like, insane. I can't post on this. Like, either it was all rights reserved, the full thing, or you're dedicating it to the public. And I'm like, look, haven't even had this published. Like, how can I give away things? Like, do you understand like how detrimental that is? And they were like, oh, we just didn't know. I'm like, okay, well, don't put it on there then. Like, that's like, what are you doing? I don't know.
Yeah, that's my frustration. Is I think it gets wrapped up in this, kind of concept of an information commons, which I think is really important. But at the same time, I think people need to understand what they're doing when they do that. And the risk for artists is that, which I think a lot of photographers don't understand, is that once it's out under that license, you can't,
right? You're
not, as a practical matter, you can't take it back.
No
and one thing that's interesting, but what's interesting though is because it's a license, I would assume it is subject to the termination provisions, and nobody's really been able to explain to me. Well, they haven't tested it yet. Because it hasn't been long enough. I don't think we've had any CC license stuff that's been out in the world long enough to qualify for termination. But nobody's explained to me how that works.
Yeah.
So if they've thought that through, or how that
so interesting,
goes together. So it's an interesting question.
So interesting. Okay, so I have a couple. Are you cool with chatting just a few more minutes? Because
absolutely.
Okay, cool. So really quick, because you're a hobbyist. First of all, your book. I haven't gotten your book, but we just ordered it for the library because I'm teaching art law. So I'm so psyched to be able to look at it and to have it. So we hopefully that's going to be part of the art law class. But second, so if people are photographers and are out there, it's at your website, and take a look. And we'll put up a link to it. But you could just go to Chris Reed, REED photo.com, and you can get to. Oops, wait, no, I'm doing the wrong one. Just do. How do we? What's your? I'm doing.
So the easiest one is actually, it's even easier now. Yeah. It's just chrisreed.com.
chrisreed.com. Chris spelled like the way we CHRIS, and then Reed is REED, no spaces.com, and then you can get to the book. And the book is Copyright Workflow for Photographers: Protecting and Managing and Sharing Digital Images. Tell us a little bit about that book first, and then I'm going to go into my other question.
Sure. So it was published a few years ago now, and I should say just at the outset, there's a few things in it now that are out of date, because it's basically designed to help photographers and other visual artists walk through how to register their works with the Copyright Office. And so bits and pieces of that have changed because the Copyright Office has thankfully updated some of its systems.
Right, that's the new thing, right? Just happened this year?
Just very recently, yeah. And that is still a much larger, they need a lot of work over at the Copyright Office, and they've been struggling to get the funding they need, and that's a whole other thing.
Yeah.
But the book was really designed, it came from, the genesis of it was when I was at the Copyright Office, working on issues with photographers and speaking to photography groups and things like that. I realized I was getting the same 5 or 6 questions every time about the basics of copyright. And so I had originally planned to just write a series of blog posts. And as I started doing that, I realized there was more to it than that. There was actually a book there. So that's when I added the kind of the workflow walkthrough stuff.
That's so great. Now, do you think you'll update it since there's new stuff?
I am thinking about it. Yeah. So I'm a little hesitant to right now because I have a feeling there's some more changes in the offing. And that's kind of the nature of these books, is that they're out of date almost as soon as they're printed. Yeah. And it's also been an interesting education in just traditional publishing because the cycle time is so long. The thing I'm working on now is even longer. And for things like this that change a lot, I'm wondering if there's a better form than a traditional book.
How did you publish it?
So this one was through Peach Pit Press, which is a division of Pearson. So it was kind of traditional, old school publisher.
So that makes it hard to update.
Exactly. Yeah. I mean, the question about whether we're going to update it is really, as a second edition is really the publisher's call. My suspicion is the economics don't work out in favor of doing that, to be honest. But it's, I own it. So
would you be able to take back the copyright and update it yourself?
I think so. Yeah. Pearson's gone through a lot of changes since I published it. So it's one of those things. And this is I mentioned this just because it's an issue that a lot of, I think, independent creators have, which is I'm not sure who to call about that, to be honest with you. And we see that a lot.
The thing that's so interesting about this, Chris, is like you are like an Uber expert. So like if you don't know who to call, how are we to figure this out, right?
Yeah, no, it's easy to see why people get frustrated with sort of copyright related things because it is very frustrating sometimes, and the big companies don't make it easy.
That's so funny. That makes me laugh. Okay, so let me ask you about registration. So you worked at the Copyright Office, and you wrote a blog post about registration and the book. So tell us about what is copyright registration? Why do you do it, and when should you do it? If you're a visual artist or a quilter or a photographer, what should we understand about registration?
Sure. So the basics, registration is not required for copyright protection, but it gives you some additional benefits. And probably the biggest one is if you register before an infringement occurs or within 3 months of publication, it enables you to get statutory damages, or to be eligible, I should say, for statutory damages and attorney's fees in the case of an infringement. And often, particularly in the case of visual arts, that's really important because the value of any one infringing use is so low, relatively speaking, that it is hard to justify the cost of litigation. And as a more practical matter, it's hard to get an attorney to take your case. And so, in the book and when I speak to photography groups, I usually preach register everything and register every 3 months so that you're never like in the book, I go through a couple different ways of doing it. You can do what I call the shoot by shoot approach, which is what I do because I don't shoot enough anymore. But if I go on a trip, when I come back, I will register all those works as a batch. People who shoot more often, I recommend they do it on a time basis. So every 3 months they register so that they're never more than 3 months away. They're never outside of that statutory damages window.
And the statutory damage window is what?
It's either before the infringement occurs or within 3 months of publication. So you have to kind of play this game where you register immediately and then before you publish. So I encourage before publication. There is a
and for you, you're taking your images and you're sending them to stock photos, so they're getting published. They're available for sale, and so you're making sure they're registered before you send them to those places. Is that what you're
exactly? So the workflow I set out in the book and what I practice is right as they come off the card. So you dump them off of the digital media card out of the camera and then register them, and that is the first step in the workflow. Technically, I suppose the first step is pulling them from the camera.
You've got a copyright workflow. Is that yours? The copyright workflow?
Yes. Mm-hmm.
And does that have that? I'm looking at it now, so let me see if I can make it bigger. So is that that's the whole idea. It's like get into the idea, right? So set your camera settings and this is down, I'll add this link. It's copyrightworkflow.com. And you have a free downloadable thing, but it's teaching you like what you should be doing to have things registered. And again, it's important to register your work if you're going to enforce your copyright.
Exactly.
If you're not going to enforce your copyright, don't register. But don't get upset if people swipe your stuff, right?
Yeah. So what often happens, though, is people don't register thinking they don't want to enforce. Then somebody swipes their stuff and they get upset and now they want to sue.
Right. Because they swipe it big, right? So you make something and then it turns out that it's on a national commercial or in Target and you're like, wait a second, that's mine. And there's really not a ton. I mean, there's some you can do, but you've lost a lot of the economic potential for recovery.
Right. And now it could be in a situation like that where the damages are so high, potential damages are so high, like the license fee would have been really high, that you could justify suing for it.
Yeah.
But just proving that can be expensive. So it alters the economics a bit. So that's why I encourage people to register, anything that's going to be released kind of beyond family and friends. I generally try to register.
And do you see the photographers doing that more? Because when they did the orphan work studies in, was it 2005? And then the first one, they weren't registering their works. Everybody, like other people were, like the sound recording industry and the movie industry and all, everybody was registering, but the photographers weren't, which I thought was really weird. Are they?
Well, it's the system is not really set up for photographers is part of the frustration. And so some of the changes I talked about a few minutes ago actually make it a little bit easier for them to register.
Got it.
But that's really one of the photo trade associations, I think, has a statistic that fewer than 1% of photographers register their works.
Yeah.
And so, it's you're right. And I don't think that statistic or that general dynamic has changed much since those reports were done. So,
and do you think it's because it's hard, because they take so many photographs, or because they just don't see? Is it like, I don't really understand why they're not using the mechanism more.
So I think it's all of the things you just described. I think it is that they shoot a lot, right? So when you talk about feature film companies or studios always registering their works, that's because they only produce 10 or 15 films a year. TV, a little bit higher volume, but still manageable. A photographer might come back from a shoot with thousands and thousands of images, and the Copyright Office, as I say, has mechanisms to make it easier. You can group them into batches of 750 images, which is still
weird, right?
It's still not a lot.
Why did they not do it bigger when they know sort of how photographers are? You know what I mean? Like, why aren't they just? I don't. Why so small?
Some of the challenge, I think, is what the public record looks like on the other end, right? So if we remember what copyright is all about, it's about creating a record of ownership. So the quid pro quo for getting those statutory damages and attorney's fees that we just talked about is that the public have some notice that your work is registered.
Right.
And for photography and really anything other than textual works, the system doesn't work that well, because if you go to my website, and there's an example of this in the book, but if you go to the Copyright Office website and you search for Chris Fried photography, you will find a bunch of group registrations, and they'll say things like,
so that's
you have no idea what's in there.
Right? And so why? Like, are they trying to solve that problem? Because that's really a problem with the old photography, because we don't have any way to know what's been renewed and what wasn't, because there's no visual record online or anywhere for people to actually access very easily, which I think is amazing that that's still a problem. Do you see the Copyright Office working on that, to have thumbnails of what you've sent in?
So they are absolutely thinking about those issues. Two points, though. One is for every photographer that says what you just said, I really wish there were thumbnails on the site. There's another photographer who says that sounds terrible because people will steal my work.
That's right. They'll just go to the Copyright Office but I mean, yes, I mean, that's very true.
So there's that balance. And then number two is this much bigger issue relating to where the Copyright Office is within the government and how much money it's got.
Yeah, and that takes a lot.
And so they need more funding and a little more independence with their IT systems to build a system that incorporates some of these image recognition tools. What the photography groups really want is a system where you can go, just like with Google image search, you can upload an image and it will tell you where that image is. And the Copyright Office would be great if you could upload one of my images and it pops back my registration record, right?
Do you think that private industry is going to be solving this problem and not the Copyright Office?
I think that is probably, I don't know that that's what's going to happen, but I think that's what should happen, is that public-private partnerships, we need to look at those and combine databases. And, the office has for years talked about and just doesn't have the funding to create an API, an application programming interface that would allow those third-party databases to talk to the Copyright Office. But if you had that bi-directional data flow with appropriate security and things like that, you could connect the public record that the office maintains with all these private databases that have sprung up.
The thing that I really want to do, and I've said this a bunch of times to people, is I would love to, and again, this is getting back to my Duratiinator hat, which is determines the copyright status of works. For those who have no idea that I have this other weird life. But so what I would love is a system that took those deposit records from 1923 to 78 at least, but even later, and especially the renewal records, and that we would have a finite, so it would be flipping the public domain search, that you could search those images and know for that period of time that if you don't find it, it's in the public domain. Because we know that so few of the photographs and the commercial labels got renewed, that if you could just make that database, we would have much better sense of what's in the public domain, at least for domestic works, But I don't know. It's like really low on people's priority list.
Well, and the Copyright Office has been doing, digitization projects for some time now, where they're scanning a lot of the old paper records, not the deposits, but the records.
Yeah.
The challenge with that is, it's really easy to scan stuff. It's really difficult and time consuming and expensive to code it so that it's machine readable and useful in some way, because you have, the registration records are in different forms based on the time.
So, right. It's like everybody, whoever got the job next made it totally a different system.
Exactly. So telling a computer, like, this is the registration number, this is the author, takes time. And then, of course, scans are never perfect. So you have to have someone go in and QC it to make sure that it's the right information. And when you're talking about legal records, that stuff's really important.
Super important.
It's just, it all comes back to funding and time and resources and all those usual government problems.
So interesting. Okay, I have two quick questions. Hobby versus professional. You're a professional photographer? Like, what makes you a hobbyist versus a professional? Is it any thoughts about that?
I tend to describe myself as a semi-professional photographer, because I don't do it full time, but I would say the quality level is of a professional.
I like that. I like degree. Semi-professional. So. That's great.
And then casual professional, sometimes I say.
What do you say?
Casual professional.
Casual professional. I sometimes call myself an extreme hobbyist.
Yeah, that's good. I like that. That's good.
Like, it's not casual. So, because I quilt every night. So, regardless of how tired, it's like kind of like drunk driving. So, like, there may be some ripping out in the morning that I shouldn't have been quilting, but I still do.
Well, actually, can I ask you a question about that? Like, is the quilting thing, do you find that you have interests that you pursue, like, really intensely and really passionately for some period, and then you abandon them for a while, but then eventually you come back to them? Or do you tend to stick with things for a long time? Like, because you like me, you wear a lot of hats, and I'm just trying to figure out, like, how do you balance all that stuff?
How do I balance my hats? Not well. So the Duratiinator was a 10-year project that I was kind of so obsessed with that my child hates it. I think I just get immersed, I think. But I think that they do, I think the other stuff, I still do the Duratiinator and stuff, so I think they go in the background. I think I really like jumping in. So I think that's the part of it. What about you? Do you feel like...
I have a hard time. So when I'm working on one thing, I feel like I'm neglecting the other things that I'm interested in. And so it's really hard for me to balance all that. Like I'm writing another book now, and that's kind of consuming all my time. But then I also have all these other interests that I want to pursue.
Isn't it? I don't have a lot of interests. Maybe that helps, right? I'm kind of myopic. Like, I really only have loved one boy, like, since I was 15, and like myopic. I have one kid, I have one major hospital. I mean, maybe that helps. I'm not very I don't have a lot of breath. Maybe so.
Well, but you found ways to bring things together. I mean, I think this is a perfect example of the quilting with the copyright. I mean, who would have known that there's so many issues there?
Yeah, and it's pretty amazing, isn't it? It's weird.
You've tied the practical and the academic piece together.
Yeah.
And so it's
so nice I think that, I don't know. That's weird. So yeah, that's interesting. What's your new book about?
So it's also about copyright.
Oh, cool.
It is an overview of the copyright review process that's been going on, or kind of wrapped up. Cool. But it's basically starts with Maria Palante, who was the Register of Copyrights at the time, the director of the Copyright Office. She gave a speech about basically imploring Congress. Yep, that's right. It was 2013, March. And she gave this talk to ask Congress to consider doing another general revision of copyright law.
Because for people who are listening, it hadn't been fully revised since 1976, but it had been like 30 years for that one. It took 30 years to get to 76, and then it hasn't been fully rehauled since then, right?
Yeah, there have been sort of minor adjustments and even some major adjustments. I mean, the Digital Millennium Copyright Act was in 98 and the Digital Sound Recording Act was in 95. And so there's been sort of bits and pieces throughout the years, but nobody's ever kind of sat down and looked at the entire act wholesale and said, well, this is, we'll keep these parts and these basic principles are still good, but maybe this is outdated, or maybe this principle needs to be updated and things like that. And so the idea was to get Congress to do that. And Congress did a version of that. They went through the Copyright Act and what they call the Copyright Review, which lasted around 3 years or so. And out of that, we've seen bits and pieces, but nothing really substantial. And the big thing that came out of that was this concept of Copyright Office modernization, which gets to some of the things we were just talking about. How do you improve the databases?
And all the records and things like that. But that's just the That's not like the law, right? It's access to records more than like.
Well, it would. I mean, some of the bigger questions are, the Copyright Office functions like an executive branch agency, but it is subservient to a legislative branch official.
Yeah.
And so, because it's in the Library of Congress, and so there's some questions around that, and so it would require a legal change to fix those problems. But the book is basically going through the whole history of that and how we ended up going from this big grand idea to getting a couple bits of legislation that, as we're speaking right now, may or may not go anywhere.
Yeah.
And so it's sort of that story. That's basically, because I thought nobody had yet had put together that whole kind of history.
That's so important too, because we lose our history. Useful. Yeah.
Yeah.
That's so interesting. Well, I can't wait to read it. I have to ask on duration. I would love to chat with you about duration at some point, because it really seemed like it got neglected it was like just barely touched. And I thought that was weird, because it is that property right. It's part of what the problem is, right? It doesn't mean that you have to make it less, but I wrote an article about it for the Copyright Society Journal. But I think there's ways to think about duration in that space that we should be thinking about. And also warning signs, like, when you start to think about things, like you may inadvertently do things that aren't helpful. So I would love to chat with you more about that if you're interested another time.
Yeah, sure. Absolutely.
All right. So that was all a little, people were like, what? Okay. We're going to end on a very exciting note, which is fair use. We're going to do fair use in like seconds. It's going to be great because we're way over time. So I want to make a costume for my kid, or I want to create artwork, or I want to sell a pattern that has there's somebody who did a woman's places in the Revolution quilt, right? And now she's selling the pattern. So what should we understand about using content owner stuff to make stuff? How do we understand when it's okay and when it's not okay? Is that it's a really hard question, but is there what do you tell people in terms of that, So at this point, Chris and I begin to talk about fair use. Now, I wanted to just interject to explain that fair use is a little bit complicated, and we're going to start explaining all kinds of copyright terms very soon, I promise. But fair use is basically, look, a work is still under copyright, but I, as a copyright holder, can't control every use that happens legally. And so the law says that other people can use my stuff for certain things, and some of those things are commenting and criticizing or news reporting. And then over time, the court has developed something called a transformative use, that somehow you are doing something with the product, with the original, that's so transformative that it doesn't hurt the market for the original, and that somehow it's okay to do this. So we start to talk a little bit about fair use, and again, we'll tease this out more in coming sessions, but I just wanted to put that out there in case people don't know what we're talking about with fair use. There are 4 factors, and we talk about that. You hear us use first factor and fourth factor. We'll get to that really soon, I promise. I'll start posting the basics about copyright very soon, but just know that fair use is a little bit complicated, and that we will be going through it.
So, I mean, the first thing I tell people is that it's, to the extent we're going to have to rely on fair use, that's a really complicated question.
Yeah.
And it's a really unfulfilling question to answer, because until a court actually answers it, we never have a real firm, we have firm, or unless there's a case that's already directly on point, we don't really have any firm guidance. But generally speaking, I kind of look at that and at the nexus of fair use and enforcement risk, right? So what is the likelihood that anybody is going to care about what I am doing?
Right. When does it matter is what I've been saying. When does it matter?
Exactly.
Does it matter? Who's going to get upset, right? That's
right.
The question.
That's right. We're saying the same thing. Yeah. But from a fair use perspective, I mean, the most important thing I think is what courts have been doing, and I don't always agree with this analysis, but is whether you have taken the original work and transformed it in some way that it no longer serves the purpose of the original work. And as I say, I have a lot of problems with that, but that is what is happening at the moment.
Right.
And I would say closely related to that is the idea of market harm. So kind of a mix of the first and fourth factors for the copyright nerds among us.
So the fourth factor has always been like, would the copyright holder have been selling it had you not done what you did? Right?
Yes, exactly. Yeah, and that includes, there is some case law that says that we should also think about licensing markets. Yeah. So that's where it gets tricky, because it's easy for a copyright owner to say, oh yeah, I would have licensed that, even if that's not quite right. So
it's complicated.
But what I think, but I think it's largely, I hesitate to say this because somebody will point to a case that shows I'm wrong, but that I think largely it's that first factor about the type of use, the transfer, and then the fourth factor, which I think a lot of courts have conflated, but improperly.
Yeah,
but that is nonetheless kind of the universe we're in.
If you can we take like 2 more seconds just to tease it out? Okay, cool. So first, transformative use has gotten really weird. So transformative used to be like, well, the Jeff Koons cases are really a good example, right? So he took a bunch of stuff and he took it from 2D to 3D, and he was like, well, I'm commenting on society. And the courts are like, no, right? He loses a bunch of cases. But then he finally gets it that he takes the bits from magazines, little bits of just things, and moves it around and says he's commenting on blah, 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 specifically about that thing. So you get this kind of, but then you get transformation cases that are like the Prince cases, where you get like, I put some blue stuff on a, so the question is what is transformative now? And I know that's an impossible question, but like, so I take, when is it, so if I have a picture of, I make a quilt that has a picture of Princess Leia on it, it's not the medium that's transformative. It's like the message or what is it that in like the photography and quilting way? Because I imagine photographers hate fair use in some way right now because they're getting slammed by it in crazy ways.
Yeah, I think the answer, you just used the word message, and I think the answer lies in that. And what I was going to say as you were talking there was that, I think we've lost sight of what fair use was supposed to be, and that's because we always talk about the 4 factors and kind of ignore the fact that there's a preamble to that, which articulates, commentary, criticism, teaching, and I think a couple other things.
Right.
And so I know that those are construed very broadly, and I think sometimes maybe too broadly, although I also think a broad if you look at fair use as being, the quote unquote safety valve to copyright being stifling speech, I think it's appropriate to construe those concepts broadly.
Yeah.
So if you can assert that what you're doing with something is somehow commenting on the original, then, that to me is a lot stronger of a fair use case, even if your transformativeness may not be quite as much, and at that point it's less about the fourth factor and more about the first factor. But I think that gets you closer to a fair use finding if there's some editorial message in what you're doing.
Now, what about fan art? Because a lot of times they're not commenting on the original, they just love it. So is that more of like the content industry recognizing that you shouldn't piss off your fans, and that it's really more about a permissible use as opposed to a legal fair use? That it's like an implied, like, okay, we still own it, but we're letting you use it because if we tell you to stop, you're going to, and it's free publicity, right? It's marketing in some way. You're doing the marketing for us. How do you do with fans, I guess?
So I think the answer is kind of, we're back to where we started talking about Etsy. I think you're right. I think it's not upsetting the fans is a key characteristic that the industry's kind of had to learn over time.
Mm-hmm.
But again, I think it comes down to just how prominent is it and what you're doing with it.
Yeah.
If it's fan art that you're selling commercially on a major website and it's getting, when I type in some major entertainment brand and the first thing that pops up is your Etsy site where you're selling posters, that's a problem.
That's a problem.
If it is, you're putting it on your, I really love entertainmentbrand.com website.
Mm-hmm.
I think that's very different.
Yeah.
If you're putting it on Facebook, I think that's very different.
Yeah.
I think that's probably not as big of a problem.
Yeah.
And to your question about who's going to care or when is it going to matter, in those situations, probably isn't.
It matters when it's economically becoming more significant or you're hurting the brand. Right. That's when it matters. Now, I know I adore you, and it's so hard to not to stop the conversation.
Okay.
But one of the things that was so weird is we went to Comic-Con here in New Orleans, and I was really bored. Not bored, but like I was waiting around for kids, right? So I was just like hanging out, talking to people, and I was asked these people, like there was a whole bunch of art in the back. And they're going show to show, and I asked them, well, do you have a license to be able to do the, whatever, My Little Pony, mashup with Doctor Who or whatever? And they said, no, we wish we did, right? That there's like in the building with the content owners, like it's going that far, right? That you could be selling content that is not yours, that's clearly a derivative work that is infringing, but they're not stopping it. I found that like really interesting. Do you have any insight into that?
No, I mean, so the type of licenses that are granted for that kind of stuff are usually, extremely detailed, extremely limited for particular products and services.
Right.
And I think it's one of these situations where the business of that has not caught up with the reality of it, and the legal implications have not either.
Yeah.
And that I think if you talk to, I don't mean to make it a generational thing, but I feel like if you talk to the newer next generation of executives and maybe even of their lawyers, you might get a different opinion or different thought about how all that fits together. But the primary concern that motivates a lot of the refusal to license that type of stuff is simply, the more people you license, the more likely it is you lose control.
Right.
And actually, most of those kind of art and consumer products licenses are very specific in terms of how, they're subject to a style manual.
Yeah.
So you have to recreate
So
things in the way that they are
intended to be. And I don't think fans would love that, actually.
No, they'd hate
So
it,
it's,
right? They don't.
Yeah.
So what I found was so interesting about this is, so when you look at like the pattern maker using Star Wars to sell like 10 patterns or 100 patterns or whatever, that same person could be at Comic-Con selling, and they're not going to get, there's still a permissible use happening. It's sort of this like, we're not making you pay, like even if you have a booth at Comic-Con and New Orleans, the content industry isn't enforcing like, don't sell that. So I found that to give us a better sense of a barometer of how serious you have to be. Does that make sense? I can't quite, like, there's a lot of stuff going on that you could just be like, hey, don't do that. But they're not doing that because they recognize the fans want it and that it's not harming them economically, or they can't stop it, I guess. I don't know.
Yeah, I mean, there may be a healthy dose of that too. The can't stop it aspect is just, then you start to get accused of, well, why did you enforce this person's thing but not my thing, or but you're enforcing mine but not theirs, that kind of thing. So yeah, I think the the industry, and we're getting there. We're slowly, just as the entertainment industries were a little slow to get on the digital bandwagon, just distributing things electronically.
Yeah.
I think this will be something we're going to have to think of more broadly. And as we move forward, going back to a point you made earlier, which is that we're all users and creators now. And that's just not something that existed before. It used to be you'd go and watch a movie and then you left the theater and that was it. And now you're immediately blogging about it and drawing pictures from it and all this other stuff, dressing up as characters. And that just didn't exist before at the same scale.
And if it did, we were doing it in the privacy of our own home or with our friends. We weren't putting it online for the world to see.
Exactly. It wasn't on Instagram, so we couldn't all see it. But I think that's a business practice evolution that's probably underway. But it's just not like everything. It always takes the big commercial ships a long time to turn. Vis-a-vis the fans and the more nimble creative community.
This is so great. You've spent so much time with us, an hour and 14 minutes, which is so unusual. So I just thank you so much. Anything else you'd like to add, or any thoughts about people, the regular hobbyists out there? Can you help allay our fears of, we want to be good citizens, but we just don't know how to be? Anything else you would suggest to them to say, don't freak out so much, or just be good? I don't know. Don't be a jerk,
I think I think it all comes back down to that primarily. I mean, if everybody just sort of tries to be reasonable and rational and understand, the big thing that's frustrating for me working for a large company with commercial interests is that people don't understand that often, there is a reason why we are taking a particular action that may not be readily apparent to you. And it's not that there's anything sinister going on. It's that trademark law requires, for example, that you take action against problematic uses of your brand, because then you may risk losing protection.
You have to police your brand, right?
Exactly. And so there's things like that I think people don't fully understand. And so, and some of it is we haven't done a good job of communicating that to these communities. And so there's room for growth, I think, on both sides. But at the same time, we love the fans and want to engage with them. And, but as long as it's done in a responsible way that doesn't hurt what we're what we're trying to do. And I don't think the fans want to hurt what we're trying to do either,
fans.
because then we couldn't do it anymore. Right.
And the irony is if they're not fans, if they're commenting, criticizing you, or doing naughty things with it, that you're, you know what I mean? Like there's a whole nother part of the law. It's fair use, First Amendment, all this
Exactly.
stuff. So that's the irony, right?
Yeah. And then I'll just say on that point really quick, not to drag it out any longer for the listeners, but, you know, we often have been accused of, you know, not respecting fair use and things like that. And nothing could be further from the truth. We have entire business units that rely very heavily on fair use for what they do. And so, and we are, you know, absent First Amendment protections, we couldn't do what we do.
Yeah. And
so the idea that we are somehow, you know, anti-fair use and just want, you know, Section 106, which is the section that provides those exclusive rights. That's just, it's ridiculous, frankly. And so
I know we could just keep talking. We just like talk for like 15 hours. People are like, how long? So, but can you explain that, just what you said? Just tease that out for people to understand, because I think that is such an important thing, because it isn't content owners versus us. Content owners are so clever, and they're very generous at this point. Like, they get it. And they're using, as you said, fair use and other parts of the law as much as we are. So can you just give us an example or explain what you meant by that?
Yeah, so a lot of the big media and entertainment companies, in addition to producing, you know, recorded TV shows and films, also have news divisions, and that may be, you know, news networks or local television stations with news departments that do the local news. They rely very heavily on doctrines like fair use to report on things. If there's a clip of video that they need to convey a story, they will go through a fair use analysis to determine whether they need permission to use it. Is the story, you know, about the subject of the video, and is that a fair use, and that kind of thing. And then, you know, just even more simply, things like movie reviews, for instance, where they'll use clips of the movie to, or book reviews, where you'll show excerpts of the book or print excerpts of the book. All of that requires the protections or enabled by the protections of fair use. So we are very much on both sides of that conversation, because our business, you know, fundamentally relies on copyright protection, but then to do that, we also rely on fair use.
That's lovely. Chris, any final comments? You are so insanely awesome. We have to, can't wait to see your book.
Thank you.
The other book is on its way, so we're going to add that to our art law class. And let's just play again. I'm writing the bigger version and then a small version for the quilter. So I'd love for you to read it, see what you think, and give us feedback, because you're just so.
I'd love to.
I adore you. You're just like so cool. I can't believe we haven't met up for a while, but you're awesome. It's great. Do you ever go to copyright conferences anymore? Do you know you have?
I typically end up at the midwinter Copyright Society meeting, because I can't.
Yeah.
Well, I find that one it's a little smaller, and I find it just a little less intimidating than the big annual one.
Yeah,
it's usually I usually have a conflict at the annual one, but I haven't been doing as many of the academic, the pure academic conferences lately, since I kind of haven't been in that space so much.
We'll have to have you come down to New Orleans. Let's just cut out all the conferences and just have you come down and hang out. So
just go direct. I'd love that.
Okay,
yeah,
we'll figure out time for you to come and play some more. And do you need to review this before we put it up, or you feel comfortable with what you talked about?
I feel comfortable. Okay. It's fine.
Yeah, there was nothing controversial or weird, or
you
didn't out your mother on some thing. She's a fugitive in law or something like that.
So. No admissions.
No, you're very careful, so it's very good. All right, Chris, you are wonderful. Thank you for your time. I really felt like we got to some really good. We had a really strong conversation that I think will help people in a way.
Awesome.
Yeah, it's great. Fabulous. All right, I will email you with a link, and I will post it fairly soon.
Awesome. Thanks so much.
All right, have a great day. Hold on just a second before I'm just going to turn off the recording. Hold on. So this is Elizabeth Townsend Guard. You've been listening to Just Wanna Quilt, a research podcast coming out of Tulane University Law School. We want to hear from you. Join our army, our quilting army. Go to our Facebook page. Suggest people